Welcome to Bankruptcy, Through the Looking Glass, with Barry Levine.
Hi, everybody. Welcome to Through the Looking Glass with Barry Levine. I'm Matt Skye. Barry is an experienced bankruptcy attorney with over 43 years in practice, focusing on helping individuals from all walks of life navigate financial challenges. Join us as we explore his insights on debt relief, bankruptcy, and financial recovery. Barry, thanks for joining us.
Pleasure, as always.
Barry, how do bankruptcy laws in other countries differ from the U.S. system?
My experience, limited as it may be, I can tell you that they're very different. I mean, I know Britain has acts of insolvency. You know, it's not a subject that I really could tell you about. I've had in years past clients that dealt with Europe in the sense of selling products. But we never reached the point of having bankruptcies and insolvencies and have that happen to us.
Let's dive into that a little bit. Can you provide an example or unique, innovative bankruptcy practice that other countries use that the U.S. maybe should consider?
I happen to think that our bankruptcy laws and our insolvency laws are, in the scheme of things, less of a Megillah, big deal, than other countries. I mean, you couldn't do necessarily some of the things that are done here, I think, overseas. It just, I don't necessarily know that a Chapter 11 is something that you would experience out in Europe someplace. But I can tell you that even here, insolvencies are a pain in the ass. I mean, I happen to be involved in a couple of them now representing creditors, which is a novelty for me. And the amount of paperwork that's going out and the work that's being done makes no sense. But getting back to the international arena, I wonder if this is a subject that we should really do, because I'm not a fount of information on it.
So from what you do know, though, let's just dive into that. Do you see U.S. bankruptcy cases as probably more complex than worldwide? Or is it, if you're in Europe, is it an easier thing to deal with?
I think that you can have a more complex case here. They have the cases I've been involved with, the Chapter 11s. One is a regular Chapter 11, and the other one is what they call a small business Chapter 11, which is supposed to be done on a more expedited basis. They both seem to be generating an incredible amount of documents and paperwork, and I don't necessarily know. The one I'm representing a creditor on, he'll probably see a dividend if he's lucky in another couple of years. I mean, it's just churning, not to say anything bad against my brother and sister lawyers, but time is time, and if you can just generate things to do, why not?
Are you seeing any interesting complexities in terms of cross-border insolvency cases?
No. It's not so. I strictly deal with Massachusetts in the scheme of things, and I guess you could say cross-border would be somebody that had a problem with something up in New Hampshire. But I don't get many of those cases. Going to bankruptcy courts in other jurisdictions is like going to a foreign country, and I try to stay away from doing that if possible. It's not healthy.
So let's jump into, how do legal frameworks handle the bankruptcy of individuals or businesses with international assets or operations? I'm sure that's pretty common.
Well, everything, if a company has international assets, it's a question of it needs to be disclosed. The real issue is a question of how, if the company, in Chapter 11, it's business as usual. So I don't necessarily think it matters if you have assets here, there, or any place. It's more the bottom line. Are they making money? Do they have any hope of reorganizing and surviving? The thing is, it's more a question of, if the case goes down the dumper into a Chapter 7, or a trustee gets appointed, how is the trustee going to administer assets overseas? It becomes a problem. You have to get counsel over there. It'll become very expensive.
When you get into some of these very, very complex cases like that, how many years or months, or what are the time frames we're looking at?
Big Chapter 11 can take on a life of its own. I mean, 2, 3, 4 years is not inconceivable. They don't end. I mean, even small business Chapter 11, can be a year or more. Nothing in the bankruptcy biz, nothing happens immediately. I actually have a Chapter 11. We're trying to sell a piece of property. It's not a big, complex case. And the buyer is ready to close, and I filed my motion to allow the sale on an expedited basis, hoping the court would shorten the notice period.
Does that kind of speak to what we've covered on previous episodes where people need to emotionally be ready for the long haul because these can drag on for so long?
Nothing happens immediately. I find giving examples. I filed a case. He had a very good business, and then COVID hit. He did plastering in people's homes, and nobody wanted them in their homes during COVID. And he had to file a bankruptcy because he had an SBA loan and a guarantee. And the court closed the case without issuing his discharge, even though we went through the whole process. And they had to administratively reopen the case and issue his discharge. And he kept wondering what happened. It was like a year and a half later. And, go argue with the clerk.
We spoke to this a little bit off camera, Barry. How do COVID-related loans and what happened during this crisis, how does that relate to a lot of the bankruptcies you're seeing today?
Well, as I was saying, what I've seen a lot of is that, during COVID, the SBA and the government did a lot of business loans, some very significant. And now that COVID is over and the businesses are back to operating in a normal universe, a lot of these businesses have found that they can't survive. And the result has been I've done a lot of liquidating of these businesses and then filing personal bankruptcies for the principal of the business because they guaranteed the SBA loan. Some of whom were unfortunate enough to have the SBA secure the guarantee by a mortgage on their house, they are now in Chapter 13s because you can't just get rid of it because the SBA has collateral to resort to. But most of the SBA loans were unsecured. And, people, at least so far, it hasn't changed. The SBA loan is dischargeable debt like any other debt.
I'm sure this is something we've covered, but just for people who are new or maybe just jumping in, can you define for us those differences between Chapter 11 and Chapter 13? I think these are the two terms we hear often.
Well, Chapter 11 is mostly for businesses. It allows them to take a breath of fresh air, pay their current debts going forward, and come up with a plan that's going to pay their creditors something. What? Nobody knows. A Chapter 13 is mostly generally for individuals. And what a Chapter 13 enables individuals to do, there are two reasons for a Chapter 13. One is household income. Everything in the bankruptcy business is tied into the size of a household and the household income. So, for instance, if you have a household of 4, you can make up to $161,000 and not have to worry about doing a Chapter 13. But if under these numbers that we have, you have to take the full means test, well, that may be a reason to file a Chapter 13 in which you're going to pay your disposable income for the next 5 years to your creditors. The other reason to file Chapter 13s is people who haven't paid their mortgages. And, sometimes people haven't paid their mortgages for years. You can file a Chapter 13, stop a foreclosure, start making your current mortgage payments, and pay your mortgage arrears out over 5 years. And that, there are a lot of people, especially recently during COVID, they were either under forbearances, some other reasons, but, I don't know if you read the foreclosure ads, they've picked up around here. For a while, there weren't any. And that's the only way, unless the bank is willing to do something with you. And sometimes it's very difficult to get banks to be anything other than dickheads, lack of a better word. But, the Chapter 13 is the easiest way to, it basically becomes a formula. If my arrears is $20,000 divided by 60, and my monthly payment is going to be that plus the Chapter 13 trustees commission.
With post-COVID, are you seeing more Chapter 11s or 13s at this point?
I tell you something, I have been staying away from Chapter 11s for a number of years. You know, the recent ones I've done have to do with real estate to try to sell a piece of property, which to me is an easier way to go about things. You know, full blown chapter 11s, they're time consuming, and 9 out of 10 don't succeed. And oftentimes you wind up spending a lot more in legal time than you get paid for. On the other hand, Chapter 13s become like mini Chapter 11s. You know, I've had cases that in the 5 years, the debtor doesn't pay their mortgage, so you deal with relief from stay and you're cutting agreements to keep the case going, you know, and I have been seeing a lot of Chapter 13s. What I tend to do, because my feeling is if I don't have to pay a client's unsecured debt in a Chapter 13, I prefer not to. They're called Chapter 20s. We file a Chapter 7 and we discharge all their dischargeable debt. We then, once they get their discharge in the 7, file a Chapter 13, and at that point, the debt that we're dealing with is just their mortgage. Or if they also have tax claims, it's just the tax claims. We're not paying 5% to anybody else. We're just dealing with debt that we have to deal with. And we've been doing a lot of those. Like I said, keeps me off the street.
Let's jump back for a moment, if we can, to cross-border insolvency. Do you have any case studies you might be able to share with us?
No, you know, I really don't. I can, you know, again, I have a couple who are going to get their discharge and they're moving to Canada. That's as close as I go to cross-border, and I'm wondering what's going to happen with their student loans. You know, they're living in Manitoba or something like that. I have no idea. But no, you know, as I said, I you know, from a bankruptcy point of view, I deal mostly with small businesses, you know, closely held companies, corporations, or LLCs. They don't necessarily, they may have products that get distributed nationwide, you know, but mostly, you know, I'm a guy who represents plumbing, HVAC, you know, restaurants, you know, mom and pop shops, things like that. They wouldn't know from international relations. Maybe an uncle who lives someplace overseas.
Speaking to that, what about the statewide? Because I assume you do see clients with a lot of statewide assets.
Well, you know, to me, if it's in Massachusetts, it's all the same. And you know, what used to be a distinction, and I don't want to bore you with legal bullshit, but when, you know, banks deal with small companies, they take security interests. Do you know what that is?
No.
A security interest. Well, the better example is like when you finance a car, the bank has a lien on your car, right? So if you don't make the payments on the car, the bank can take the car. A security interest is sort of the same thing. The bank has lent your company money, and your company has assets, and your company has you sign a security interest, and they file a UCC, which gives them a lien on your collateral, okay? And the thing is, when assets used to be held in different places, you had to file a UCC at the Secretary of State's office. This is in Massachusetts. Probably was nationwide. And in the town they were doing business. So if you were representing a bakery that had its main premises in Malden, it's a little town here you may not know, you would have to file a UCC in Malden. Somewhere along the line, I don't know how many decades it's been, you just file that UCC with the Secretary of State. But to do it in both places, when you had assets throughout the state, that was necessary to perfect your security interests, which means that you could then, you had a lien against everybody else. I know it's very boring.
No, it's very relevant, I think, in a lot of ways. And let's zoom out for a second. You've got 43 years of experience. You've been around the block. How have past global financial crises influenced bankruptcy trends worldwide? What trends have you seen?
I still see, I see businesses that they can't pay their debt. I don't see any trend in any industry or anything like that. Most of the businesses that I see are, like I said, are small businesses, and it's tough. They find it very difficult to keep up with, both their secured debt, taxes, withholding, sales tax, meals tax, and then their unsecured creditors.
Are there any lessons we can take away from past economic travesties, if you will?
Keep some money in his shoe. I don't know. From an individual's point of view, the best thing is to protect for when the shit is going to hit the fan. And to do that is to try to make yourself judgment proof to the extent you can, and not try to do that, a week before the IRS is going to record a lien against you. There's certain proactive things that you can do to protect your assets. Massachusetts, as states go, happens to be, in the scheme of things, is fairly liberal, because in real estate you get a $500,000 homestead exemption, and if you're over 62, such as myself, you get up to $1 million homestead exemption. So from a creditor's point of view in a bankruptcy, unless you have more equity than that, it's irrelevant. So what else, but the thing is, people do things with real estate that can, like parents adding a child to title, and then the child has financial problems, and now the child has to deal with a piece of real estate that they don't own, but they don't live at, but they own. Everything. It pays to discuss things in advance with people, but people very often, I don't listen to my wife, and she'll let me know this all the time.
You said judgment proof. That stood out to me. How can someone be judgment proof?
You have no assets in your name or equity in your assets that anyone could attach. It's like, a good example, it's a long time ago when Mexico was a debtor state and the world kept lending it money. Mexico owed so much money that they couldn't default. So that's why they kept lending it more money. But when you're judgment proof, nobody was going to get anything from them. When you're judgment proof, what are they going to get?
So, Barry, as we wrap up, if you have one major takeaway for our audience, what would that be today?
I feel like saying only you can prevent forest fires.
That's some good advice. I would take that.
Financial advice is prepare for the worst. It makes life easy.
Makes sense. Everybody, thank you so much for tuning in to Through the Looking Glass with Barry Levine. For more information or to connect with Barry, visit levineslaw.com. You can also find him on social media. Barry, thank you so much for your time today. It's been a pleasure.
Stay well. Good to chat with you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.